Today on Legalese, we are discussing the decision in the Supreme Court case of Gonzalez v. Trevino. Hey, greetings everybody, and welcome back once again to Legalese. As always, I am your host, Bob, and I want to thank you all so much for joining me here today. Now, if you happen to be new to my channel, let me especially welcome you. This is a podcast where we're going to be discussing all things constitutional law, as well as current events in other areas of law, politics, and culture. Now, let me remind you guys real quick, if you want to find out more about the show, you can go check out our homepage over at legalespodcast.com. And if you want to stay up to date whenever I post new content, because I don't just do videos on YouTube, I post to alternative platforms. I write a lot of articles over on Substack. And if you want to get notifications for some or all of those things, all you have to do is head on over to legaleshow.com. There you can subscribe to our newsletter and get notifications sent right to you. All right, well, we got a lot to get to today, so let's just jump on in.
Dive on in!
So, ladies and gentlemen, boys and girls, children of all ages, we have a wonderful, fantabulous video for you here today on Legalese. Now, some of my most popular videos of all time, and I've been doing this channel for some almost 5 years now. Some of my most popular videos happen to be a series of videos I put out just a few months ago following the case of Gonzalez v. Trevino. Now, we have been following this case all the way through the Fifth Circuit onto the Supreme Court's grant of Sylvia Gonzalez's petition for cert, and of course, the oral arguments in that case in which Anya Bidwell, attorney for the Institute for Justice, gave truly one of the finest presentations of any counsel of record whose oral arguments I have ever covered on this show.
We'll hear argument first this morning, case 22-1025, Gonzalez versus Trevino. Ms. Bidwell.
Mr. Chief Justice, and may it please the Court. Respondents try to overread Nieves in two ways. They need to win on both attempts. Each is wrong and would lead to results this Court could not have intended. First, respondents say Nieves' rule, designed for a representative case of in-the-field law enforcement, now insulates all government officials. Picture the thin-skinned bureaucrat scouring for a crime to pin on his critics. According to respondents, Section 1983 has nothing to say about that. Second, respondents parse Nieves like a statute to say that it limits plaintiffs to a particular type of comparative example. To be sure, Nieves did recognize that evidence of subjective motive alone would not get a plaintiff an inference that this motive caused the adverse action. But Nieves does not blind courts to all but one type of objective evidence of causation. Respondent's position extends Nieves beyond its moorings. If the mayor in this case got in front of TV cameras and announced that he was going to have Ms. Gonzalez arrested because she challenged his authority, the existence of probable cause would make this evidence legally irrelevant. Respondent's position would also toss out of court a critic arrested for jaywalking on a remote country road, even if his town had never arrested anyone for jaywalking before, simply because he couldn't find a non-critic who jaywalked on the same spot. Nieves balanced important First Amendment concerns to protect the on-the-street first responder, making a now-or-never decision to arrest a suspect in his grasp. It did not so loosely dispense with the First Amendment interests as to give government armchair quarterbacks a free hand at the time of their choosing to punish their critics. I welcome this Court's questions.
And it is for that reason that I could not be more pleased with the update that I can give you guys in this case. Now, earlier today, the Supreme Court issued their opinion in Gonzalez v. Trevino, and it is truly a red-letter day for Sylvia Gonzalez, as, in all important regards, she has prevailed in her case.
And there was much rejoicing.
Now, one would expect that the court would issue a regular signed opinion that notes the authorship of the majority opinion. But the court would do something different. Here, it would issue a 5-page per curiam opinion, reversing the Fifth Circuit. Now, the upshot of a per curiam opinion is that we do not know for sure who joined it. Now, Justice Alito wrote a 16-page concurrence, Justice Kavanaugh wrote a 2-page concurrence, and Justice Jackson wrote a 2-page concurrence, which was joined by Justice Sotomayor. So we can say for sure that Alito, Kavanaugh, Jackson, and Sotomayor joined the majority. But that leaves us asking, who was the fifth vote? Now, all we can really say for sure is that it was not Justice Thomas, because he would dissent in this case. And this means that ultimately, what we do not know is how Chief Justice Roberts, as well as Justices Kagan, Gorsuch, and Barrett voted in the case. Now, this naturally leads to the question, why is it that the court would issue a per curiam opinion? Now, I think it is certainly possible that Justice Alito was assigned the majority opinion but lost it, and that the chief would come in to salvage the majority with a narrow per curiam. And at present, Alito actually does not have any assignments from the March sitting. Now, another possibility is at least one of those four did not want to signal their joining of the majority, but they also didn't want to join Justice Thomas's dissent. Now, my own personal guess is that this is Justice Gorsuch, who tends to be very skeptical of law enforcement matters, which is part of why I love him so much. But to be honest, one cannot be sure of these things. So now, with these initial caveats out of the way, let's step back to where this all began. In the case of Nieves v. Bartlett in 2019, the Supreme Court held that, as a general rule, a plaintiff bringing a retaliatory arrest claim must plead and prove the absence of probable cause for the arrest. Now, at the same time, the court recognized a narrow exception to that rule. The existence of probable cause does not defeat a plaintiff's claim if he produces, quote, objective evidence that he was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been, end quote. In Gonzalez v. Trevino, the court said that showing does not require very specific comparator evidence indicating that identifiable people engaged in very similar conduct were not arrested. Now, a press release from Sylvia Gonzalez's attorney, Anya Bidwell, would proclaim, "This is a great day for the First Amendment and for Sylvia Gonzalez, who has courageously fought back against retaliatory actions by government officials." So, with that in mind, let's briefly review the background facts of Sylvia Gonzalez's case. Now, Sylvia Gonzalez, who is a 76-year-old woman and the first Hispanic woman elected to the city council in Castle Hills, Texas, was charged in 2019 with violating a state law that makes it a crime to intentionally tamper with government records after she placed a petition she had initiated criticizing the city manager in her binder. Now, Gonzalez says that she accidentally picked up the petition after a long meeting. And so the mayor of that city, Mayor Trevino, brought this incident to the city police's attention, and an investigation into these events would begin. And within a month, a private attorney.
And as for your case, don't you worry. I've argued in front of every judge in the state, often as a lawyer.
Tasked with leading the investigation, concluded that Sylvia Gonzalez had likely violated a Texas anti-tampering statute that, among other things, prohibits a person from, quote, intentionally removing a government record, end quote, according to Texas Penal Code sections 37.10A3 and 37.10C1.
How about that? I looked something up. These books behind me don't just make the office look good, they're filled with useful legal tidbits just like that.
Now, on that private attorney's request, a local magistrate would grant a warrant for Sylvia Gonzalez's arrest. When she was informed of this, Miss Gonzalez turned herself in. She was booked and spent the evening in jail. Now, ultimately, the moment he heard about these charges, the district attorney ultimately dismissed those charges.
You'll get nothing and like it.
And Miss Gonzalez claims that this episode convinced her to step away from political life. But more importantly, following her arrest, Sylvia Gonzalez would bring suit under 42 U.S.C. Section 1983, which is a statute that should be very familiar to viewers of this channel. We talk about it all the time. This is the statute for a deprivation of rights under color of law. It is a common law cause of action. And in federal district court against Trevino, along with the police chief and the private attorney in their individual capacities, her complaint would allege that she was arrested in retaliation for her role in organizing the petition against one Ryan Rapely for his removal, and that the defendants therefore violated her First Amendment rights. Now, to bolster her claim, Gonzalez would allege that she had reviewed the past decade's misdemeanor and felony data for Bexar County, where her local city of Castle Hills is located, and that her review had found that Texas's anti-tampering statute had never been used in the county, quote, to criminally charge someone for trying to steal a non-binding or expressive document, end quote, just like the petition that she had been accused of moving across a table, essentially. Now, the defendants would move to dismiss this complaint, and they argue that the presence of probable cause defeated Gonzalez's retaliatory arrest claims against the individual defendants. Now, the district court, which initially heard this case in the Western District of Texas, would deny this defendant's motion. And even though Gonzalez would concede that probable cause indeed supported her arrest, the court allowed her claim to advance after finding that it fell within the exception to the no probable cause rule that the court recognized in Nieves. However, the Fifth Circuit Court would reverse that decision on appeal. Now, the court thought that a plaintiff's claim could fall within the Nieves exception only if the plaintiff proffered comparative evidence of otherwise similarly situated individuals who engaged in the same criminal conduct but were not arrested. And Gonzalez's claim failed because she did not provide, according to the court, such evidence. And Gonzalez brought her case to the Supreme Court seeking a reversal on two grounds. First, she asked the Supreme Court to reject the Fifth Circuit's rule that plaintiffs must use specific comparator evidence to demonstrate that they fall within the Nieves exception. Second, Gonzalez contends that the Nieves no probable cause rule applies only to claims predicated on split-second arrest rather than, as in her case, a deliberative arrest. And just earlier today, on Thursday, in a 5-page opinion, the Supreme Court would send Gonzalez's case back to the Court of Appeals for another look. And the Supreme Court's holding would be that the lower court had construed the Nieves exemption too narrowly. Because the justices decided that the Fifth Circuit was wrong to deem such evidence insufficient on its face, they vacated the appeals court decision and remanded the case for further consideration. But Gonzalez still has to prove that she was a victim of a political vendetta. Now, the Supreme Court would say in their per curiam decision that although the Nieves exception is slim, the demand for virtually identical and identifiable comparators goes too far. They note that Gonzalez's evidence was enough to allow her case to move forward, and the court reasoned because the fact that no one has ever been arrested for engaging in a certain kind of conduct, especially when the criminal prohibition is long-standing and the conduct at issue is not novel, makes it more likely that an officer has declined to arrest someone for engaging in such conduct in the past. Now, the court would decline to address Sylvia Gonzalez's second argument that the Nieves exception applies only to claims that arise from split second arrests rather than to all arrests more broadly. Instead, the court sent the case back to the Fifth Circuit for it to determine whether the evidence that Gonzalez had offered is enough to meet the Nieves standard. Now, that's pretty much the end of the per curiam opinion, but we had several additional opinions by several of the justices on the court that I want to cover here real quick. Now, for example, Justice Samuel Alito would write a concurring opinion that, as he said, was intended to provide more guidance to courts dealing with such cases in the future. So he rejected the defendant's arguments that if plaintiffs are not required to provide the kind of strict comparator evidence demanded by the Fifth Circuit, that they will be able to circumvent the whole purpose of the whole probable cause rule. Now, Alito emphasized the court should not conflate the question of whether certain evidence can be considered under the Nieves exception with the entirely distinct question whether the evidence suffices to satisfy this threshold inquiry. And also, in Alito's view, the Nieves rule applies to all arrests, not just those made on a split second basis. In addition to questioning the strength of Gonzalez's case, Alito faults his colleagues for declining to address another question raised by her petition: whether the general rule that probable cause for an arrest blocks a First Amendment claim should be limited to cases involving split second arrests rather than deliberative ones. And in this case, the investigation that resulted in Gonzalez's arrest took nearly 2 months. And in another concurring opinion, Justice Brett Kavanaugh notes that Gonzalez conceded, perhaps unwisely, that there was probable cause to arrest her, meaning there was evidence that she had intentionally removed a governmental record. And so, as Kavanaugh sees it, her argument that she was arrested for an honest mistake is not a Nieves exception claim at all, because it hinges on her state of mind rather than her conduct. Now, Justice Brett Kavanaugh would also file his own concurring opinion, and he suggested that the court was looking at the wrong question because, as he put it, Gonzalez's argument turns not on her conduct, which is taking government records, but rather on whether she intended to do so. Therefore, Kavanaugh contended, Nieves does not apply at all. But he nonetheless would agree that the court's opinion was okay because, as he put it, quote, it does not seem to say anything that is harmful to the law. Justice Ketanji Brown Jackson wrote a concurring opinion, which was joined by Justice Sonia Sotomayor, that was notably more sympathetic to Gonzalez, as you might have expected based on the questions that both justices would pose during oral arguments in the case last March. Now, in addition to the survey of document tampering cases, Jackson notes Gonzalez pointed to among other things, details about the anomalous procedures used for her arrest, and statements in the arresting officer's warrant affidavit suggesting a retaliatory motive. Now, that sort of evidence, Jackson would go on to say, also can support the conclusion that Gonzalez was arrested when otherwise similarly situated individuals not engaged in the same sort of protected speech had not been. Now, additionally, Justice Clarence Thomas, as I had sort of worried about, did dissent from the court's decision in this case. Now, in his dissent, he reiterated his belief that to bring a claim alleging an arrest in retaliation for the exercise of a First Amendment right, a plaintiff, quote, should have to plead and prove a lack of probable cause, end quote. Now, Thomas's dissent in this case was really actually quite interesting because for those of you who watched my video covering the petition for cert in this case, you may remember I had gone off on a bit of a tangent, expressing the fact that while Clarence Thomas is usually very good on First Amendment issues, that when it comes to claims under Section 1983, he is a stickler for requiring the application of a common law cause of action that was considered settled law at the time of Section 1983's enactment, which goes back to the Civil Rights Acts of 1871. This is because Justice Thomas has always been very skeptical about the notion of First Amendment retaliation claims, especially brought under Section 1983. Primarily because the way he reads the phrase in Section 1983 under color of law, in his view, doesn't leave room for intentional torts. Now, on the other hand, he is, broadly speaking, always interested in exploring common law analogs of causes of action that did exist at a time a law was enacted, if such an analog does exist. And he's not wrong for doing this, too. He is right about that. Now, because of that, it was very clear that this would be an issue. And because Sylvia's case was relying on the Nieves precedent, and in Nieves, Justice Thomas would write in his concurring opinion for that case, because no common law tort for retaliatory arrest in violation of the freedom of speech existed when Section 1983 was enacted, we look to the common law torts that provide the closest analogy to that claim. Now, I was certainly not the only person who was aware of that possible wrinkle, and in my video covering the oral arguments for this case, I actually devoted much of the first part of my video to a fascinating exchange that took place between Sylvia Gonzalez's attorney, Anya Bidwell, and Clarence Thomas. And this was because Miss Bidwell had seen this coming as well as I had, and she made what I thought was a very good and valiant attempt to provide Justice Thomas with a sufficiently analogous common law cause of action.
In Nieves, we dealt with an arrest. And is it different here because you have a warrant process, you have an investigation? Does that break the causal link that we would have in a case just where a police officer arrests the plaintiff?
No, Your Honor, it doesn't. In fact, the fact that warrant exists here helps us for two reasons. Number one, we have an analog at common law, abuse of process, because warrant is a classic legal process. But number two, when it comes to but-for causation, magistrates are required to look at the arrest affidavit in order to issue a warrant. So the arrest affidavit, which we say would not have been issued had it not been for retaliatory animus, is something that magistrates have to take into account, and it is a but-for causation. And as this court explained in Bostock, and just this term in Murray, there could be many but-for causations. Our burden is to show that had it not been for animus, that arrest would not have occurred. That's just one but-for causation, one but-for cause, and we meet that requirement here.
You say that you used abusive process as the analog. Have we ever used that in in these retaliation cases?
You didn't, but that was because there was no process. So in Lozman, you had an on-the-spot arrest. In Reichel, you had an on-the-spot arrest. In Nieves, you had an on-the-spot arrest. So this is the first time that this court actually sees a case with a warrant coming before it. And just as at common law, a plaintiff could bring a claim, even if there was a warrant. For example, in Jackson versus American Telephone Company, there was a warrant for a serious offense. It was a warrant for assault with a deadly weapon, and it was properly issued, but a plaintiff still had a cause of action because that warrant was used as a pretext for private purposes inconsistent with the exigencies of the writ, in the words of common law.
Before we go, let me very briefly try to explain why Justice Thomas was, in fact, the lone dissent on this case. And this is what he had to say in his dissenting opinion in the case. He said, as I have previously explained, the common law torts most analogous to retaliatory arrest claims are false imprisonment, malicious arrest, and malicious prosecution, all of which required a plaintiff to prove the absence of probable cause. He notes that Sylvia Gonzalez herself concedes that there was probable cause for her arrest, and that her retaliatory arrest claim, therefore, cannot, in his opinion, proceed. Now, resisting that conclusion, Sylvia Gonzalez would contend that there is still another common law analog for a retaliatory arrest claim, and that is abuse of process. Now, he says although the exact contours of that tort are unclear, abuse of process generally address the extortionate perversion of lawfully initiated process to illegitimate ends in accordance with the decision in Heck v. Humphrey. And he says, critically, for Gonzalez's argument, an abuse of process claim did not require a plaintiff to establish the absence of probable cause. Whether or not Gonzalez is ultimately successful in proving her case, today's decision will make it easier for victims of retaliatory arrest to get their day in court. Laredo, Texas journalist Priscilla Villarreal, for example, was arrested under a dubious interpretation of an obscure state law that makes it a felony to seek non-public information with the intent to obtain a benefit. Her crime, according to local police and prosecutors, was asking a cop questions about a public suicide and a fatal car accident. Villarreal, who is seeking Supreme Court review of a Fifth Circuit ruling against her, says her real offense was irking law enforcement officials. The objective evidence supporting Villarreal's retaliatory arrest claim seem even stronger, actually, than the evidence presented by Gonzalez. And as over half a dozen journalists already have noted in a brief supporting her Supreme Court petition, the legal theory deployed against Villarreal would make a felon out of anyone who asks a government agency for information that is deemed exempt from mandatory disclosure under the Texas Public Information Act. Now, that happens thousands of times every year, as documented by the opinions that the State Attorney General's office issues in such cases. Yet those unsuccessful information seekers have never been arrested or prosecuted for the crime that Villarreal was accused of committing. Based on the Supreme Court's clarification of the Nieves exception, that surely should count as objective evidence of a retaliatory motive. It therefore does seem possible that the court will remand Villarreal's case for reconsideration in light of Gonzalez. And the Supreme Court's revision of its First Amendment retaliation doctrine ensures that Americans can seek justice when they have evidence of a retaliatory arrest. Retaliatory arrests undermine the very foundation of our democracy And this ruling in the Gonzalez case helps safeguard the rights of all Americans to speak out without fear of retribution. And Anya Bidwell and the Institute for Justice say that they were proud to have been part of this crucial victory for free speech, as well they should be. Well, anyways, that's really all I have for you guys here today. Thank you so much for tuning in to Legalese. As I mentioned, we have another video coming very, very soon on Moore v. United States, which is another very important case. So be looking out for that, which is why you're going to want to subscribe to the channel so you make sure you get notifications when that video comes out. And of course, if you would please do all of those other things for me that help to trigger Al Gore's rhythm, if you like this video, hit the like button. If you disliked it, you could be a dick and hit the dislike button if you wish. Leave me a comment. Let me know what you thought about the video. And until next time, this has been Bob for Legalese, talking about Gonzalez v. Trevino, and of course, as always, Cartago de Lenda Est.